Good afternoon. Let's try this again. Good afternoon. Good afternoon. All right. I know it's always difficult to get together after lunch, and 2:30 in the afternoon sessions can be very deadly. So I think you will find this to be fairly entertaining and very informative at the same time. The format is something new for NATOA. MACTA, the Minnesota chapter for NATOA, has been doing this for the last couple of years with a slight twist to it. As a production for programming, it's been called 60 Tips in 60 Minutes. And so NATOA is stealing it, and theirs is going to be 60 answers. I think it's 60 questions in 60 minutes, but given the fact that we have 3 attorneys here, and we only have we actually have 75 minutes, so even the title of the session is a little misleading. But my job is going to be to make sure they try to stay as succinct as possible in their answers so we can see how many questions we literally can get done with answers within that 75-minute frame. I will give a very, very short, brief bio for each one of them, as their full bios are in the packets as well as online and everything else. So I'm not going to spend a lot of time. I always figure if people have been asked to be on a panel, they've been asked for a reason, so let's just assume they know what they're talking about. First gentleman to my immediate right is Ken Fellman. He's a partner in the Denver law firm of Kissinger and Fellman, and his practice emphasizes local government representation and telecom law and blah, 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 blah. He's a former mayor and city council member in Arvada, Colorado. He's been involved with the FCC. He won the NATOA's 2006 President's Award, and he's the 1998 Member of the Year for NATOA. All right.
Which is the last time we were in San Diego.
Which was the last time? Well, really? Okay. It's been a while then. The person between the two gentlemen is Gail Karish. Gail focuses on telecom law as well. Gee, go figure. Assisting clients, mainly local governments and municipal utilities. She is a member of Best, and Krieger, or for us a little closer to the firm, BBK, and she practices law for that group, formerly with Miller and Van Eaton. And Gail, you are located here in California, right?
In Los Angeles. In
Los Angeles. And to the far end, but not least at all, is Tim Lay, partner in the Washington, D.C. law firm of Spiegel and McDermott. And guess what? He also practices in telecom law with clients and local government. So we see a trend here. He is also a Member of the Year of 2006. So, Gail, what's your problem with this?
Just not that good.
Oh, okay. Well, when we were preparing for this, when we got together as a group to prepare for this, I said the best news is none of you have to worry about doing a presentation. And we thought that was really cool. But we all had homework assignments, and that was to come up with 2 questions each, just in case the audience was a little shy in asking questions. In addition to that, Steve Traylor, for whatever reason, was concerned that we weren't prepared for this session. So he devised 3 pages of questions for us. So, just to make Steve happy, I'm going to start off with 1 question. What I'm going to do is give a softball here to all 3, have them answer it, and then I'm just going to roam the audience, and hopefully you will have questions. If you don't, we'll have to rely on our questions, and they're very tough ones. And I'll throw this one out first to Ken, who works very closely with the FCC. Ken, who is your favorite FCC commissioner?
Oh, boy.
They're asking questions already. This is great.
My favorite FCC commissioner is the last commissioner to come to a NATOA meeting, so today it's Chairman Wheeler.
And it won't be fair to ask the other 2. I just wanted to put Ken on the spot there. Another one of the softball questions, and I'll throw this one to Gail, is...
That was a softball question.
Okay, it wasn't too soft, but it was short. Will legislation ever keep up with technology? Gail?
No.
See, we're going to keep this rolling right along. And Tim, I think we had a question for you, but I really can't. I know. How many years did Joanne Hovis serve on the NATOA board?
This is like Monty Python and the Holy Grail. I get that one. My short answer is I don't know.
Good answer. All right, so I really don't want to rely on the questions we have. This is free legal advice, folks. Free legal advice. You get to ask them any question regarding telecom, cable, broadband. If you have an issue regarding a lawsuit, a will, something else.
No custody questions today, please.
Not the panel, but anything involving NATOA issues is. And we'll have the first question back here. Introduce who you are.
Okay, I'm Jay April. I'm from Maui, Hawaii. I run the PEG Access Center there. One of our state senators asked me a question yesterday. Well, we're afraid that if Charter buys Time Warner, we have to sell to Charter. If the state of Hawaii says no, we won't have a cable system. How would you answer that if the state senator asked you that question?
Wait, I didn't, we have to sell to Charter, did you say?
Well, Charter's buying Time Warner.
Right.
So the state's waiting for what the FCC is going to do, or DOJ, right? So let's say the sale goes through, but the state doesn't want to approve the sale. The state feels they have to approve the sale, they have no other choice. How would you advise the state senator if she asked you that question? Does Time Warner have to be,
Right.
in other words, does Charter Communications, can the state refuse the sale?
Yes.
And then what happens if they do?
All right, so the first part, yeah, each state law is a little bit different. I would tell you in my state, and I know Ronald Brise is here, so he might want to chime in from Florida, that the State Public Utilities Commission gets to determine whether the transfer of the licenses are in the best interest. And the feds could say yes, and the state PUC could say no. What happens at that point is a lot of lawyers make a lot of money.
And the only thing I'd add is rest assured, whatever happens, you will have a cable system that will be providing service because somebody's making money off of that.
And I would just add that the merger agreement. Okay.
You got it. It's on.
See,
It's on.
I figured it out. I would add that the merger agreements always deal with that issue of regulatory approval. So if you have the time to go through the 100+ pages of the agreement and find the section, there will be something on regulatory approvals that will say exactly what happens if they don't get some. Sometimes there's a threshold that the whole transaction will fail if they don't get a certain number of approvals.
Another merger. Dwight Williams with City of Houston. Another merger question. AT&T buying DirecTV. What does that do to cities or localities in their pulling those two things together? Is there any legal issues that cities need to look at or understand?
Well, I think over time, what you're going to see, this isn't a legal issue so much, over time, what you're going to see is AT&T is going to migrate all of its video off of the UVerse terrestrial system onto DirecTV. So they'll basically free up more broadband capacity on their terrestrial network by taking the video off of it. So what you will see over time is you will no longer be receiving franchise fees from AT&T for video, and there won't be any PEG channels on AT&T's DirecTV system. That's what you'll see over time. And then the other shoe to drop after that will be over time. At some point, Comcast and all the rest of the cable operators are going to go to Congress. They're going to go back to state legislatures like Texas. They have state video franchising laws and say, AT&T is bigger than any of us, and they're not paying franchise fees, and they're not paying PEG fees. We shouldn't have to either.
So what's the negative side? Gail, Ken, comments?
I just would add that for AT&T, it's pretty easy to get out of the video market because they are the ones who marched all around the country getting the state video franchise regimes that usually let them off the hook with, a simple notice to customers and things like that. So unlike a regular local cable franchise that's a commitment for a certain number of years, I think it's a pretty easy out in a lot of states.
Right. I have nothing to add.
Next question. Yes, Pam. Pam Varian.
Under the FCC wireless siting rules, is the shot clock applicable to right-of-way requests? If Verizon wants to use our street lights, are we under a shot clock to have to respond with them by a certain period?
The status of the right, I mean, to back up a little bit, if you're talking about the wireless siding, whether you're talking about the 332C70, 90 and 100-day shot clocks, or the 64 or 960 day, I think the answer for your streetlights is clear. Neither's provision applies to cities acting in their proprietary capacity. The streetlights themselves, the shot clock shouldn't apply. Right-of-way access, that is a fuzzier question because a lot of it will depend upon state law, whether your interest is in the right-of-way really is a proprietary interest or some other kind of interest, and that may vary from state to state. But for streetlight, I think you're acting in proprietary capacity in the streetlight.
Well, let me complicate that a little bit more. It depends on who owns the streetlight. So if you have the
I'm assuming the city owns the streetlights.
Okay, if the city owns the streetlights, yes, I agree with Tim. If it's an investor-owned utility, or if it's just a pole in the right-of-way, then the issue becomes, is it an eligible facilities request under the new rules? So if there are no facilities on the light, then you're not subject to 6409. But once you start allowing, say, a DAS system on a light, and then they want to put a second one on, now it's a co-location, now you do come under 6409. So it depends on ownership of the vertical infrastructure, and is it the first attachment, or is it a co-location?
Yeah, and just be careful because it doesn't have to be a wireless antenna in the typical like cell site sort of form. It can be any kind of wireless, unlicensed or licensed.
I'm impressed. We're 15 minutes into it, and it was the first time a lawyer said, it depends. So.
Hi, good afternoon. I'm Mark Rosenberg with the City of Las Vegas. My question is about closed captioning. Have you heard about where we are with being forced, or stations have to run closed captioning? I don't know if there's legislation or it's FCC rules, but I've heard that they're working on that. Does anybody have any update on that?
It's been a while since I checked, I mean, like a couple of months. There was local government's PEG channels are not required to close caption under the closed captioning rules, but at least when I've analyzed the issue before, for some of our local government clients, there is a pretty good chance that you could still get an ADA claim if you don't provide closed captioning. There's a separate proceeding pending at the DOJ right now for closed captioning for websites and video streaming and other kinds of government media, and that is still pending as far as I can tell.
Anything else?
The only thing I'd add is, and I don't remember the date, I think it's in November, the FCC is actually having a workshop on PEG and closed captioning in November.
It's actually November 10th, which is a Tuesday, and it's about a 4-hour session. It will be streamed live, and I would encourage you strongly to get that on your calendar. I know Mike Wassner and Mitzi are both going to be involved with that, and I know a lot of cities do have concerns with closed captioning. I think it was a great question.
Kit Lammers, City of Lakewood in Colorado. Since the merger failed with Comcast, what's their next big move, and do you think they'll buy Netflix?
We have 5 members of Comcast sitting right over there. Maybe they should answer that question.
Yeah, can we call a friend?
Yeah, phone a friend. Kit, I don't know. It's far be it for me to predict what Comcast is going to do next.
Does Comcast have an answer to that? Do they want to make a comment?
He's
No comment.
No, Michael is emailing Brian Roberts as we speak to see if we can get an answer.
Next question.
Jerry Musial, life member. Damn glad to meet you. More of a pie-in-the-sky opinion. Based on, providers moving more services into the streaming internet area, which we know is regarded as information services, exempt from fees. Would there be a day when more services are moved there? FCC, Congress might move to put fees on those internet services because broadband fiber still runs through the rights of way.
But the general, you're absolutely right. I mean, as far as revenue streams for broadband video voice providers, the broadband part of the revenue stream is growing. The video part is flattening, and some people think it will start dropping. from local government's point of view, from a fee revenue or even tax revenue, yes, I mean, you would think that you could actually, the usual theory with taxes and fees, you broaden the base, you can lower the rate. So yes, you could say maybe Congress should look at that. Don't be real optimistic that they'll act on it without a lot of effort, because it's a freebie for Congress. They have something called the Internet Tax Freedom Act, which basically means broadband services are immune from all state and local taxes, and if you're industry, you're not going to give that up. There's no reason why you should give it up, and if you're Congress, that you can be against taxes by federally preempting state and local taxes and fees, and you don't have to pay for it. State and local governments have to pay for that out of their budget, so it's a freebie. So it's a very difficult political climb. You're right, as a policy matter, that should change. I think politically, at the federal level, it'd be a very tough haul.
Except I think on universal service, right?
Well, universal service fees, but
Yeah.
those in essence are redistribution among providers. Those don't go to general revenues. That's just a mechanism for providers pay into the bucket,
Right.
and then the bucket goes out
Right.
to other providers.
Any follow-up from other?
Yeah, I'm not real confident that Congress is going to do something progressive, Jerry. Maybe after they get immigration right, they'll look at the Communications Act. But if I were king of the world, which I'm not, and we were looking at a new Communications Act, I think we ought to see something that would be technology agnostic, and there would be a public interest obligation for any kind of communications entity that utilizes public property to pay some percentage of gross revenues for the use of that public asset. And so whether you're broadband or video or voice or whatever you want to call it, and maybe the percentage isn't 5%, maybe it's more people paying into a pie at a smaller amount, but there ought to be a recognition for the use of that valuable public asset. And if we ever get closer to a Communications Act rewrite, those would be the kind of issues I would hope that they would look at. But I agree with Tim. Usually when stuff is happening in Washington, it's not good for us.
And the only thing I'd append to that is, we've talked about it would be a tough haul with Congress. In many states, not all states, you have another problem, and that's called your state laws, which erect similar hurdles. And in my experience, a lot of times state legislatures are even less receptive to progressivity than Congress is, which is not a high compliment.
Kind of following up on that, and I'll come to you in just a second. I think this is a really good question. What's the next big telecom issue for local governments? We'll let you think about that, because I think that's a great question. What issue that may be coming down the road that you've thought about, that you may have crystal balled on a little bit, but you really hasn't really come to the surface yet? So we'll think about that. We'll get Mr. Garrison with his question. We'll come back to you about that one.
Just to follow up for Ken, how do we be technology neutral but not technology blind? Because certain technologies have capabilities over and above others, and it really depends on what you need to do.
When I'm talking technology neutral, I'm talking about not focusing on what the technology does or how effectively or ineffectively or what capacity it has. If it is using public property to assist a private enterprise in generating a profit for its shareholders, there ought to be a public interest obligation for that use. And if I put my mayor hat on, right, as an elected official, I'd like it to be the best technology ever, but it's not really my job to tell somebody else how to run their business. It's my job to say, if you want to rent this space in my public property from my city, this is what you're going to pay for it, and I'll leave it to you to make your product as efficient as it possibly can be. I hope that was responsive.
I would just say, where you're talking about public investments of dollars, not just the permission to be in the right-of-way, how do we evaluate that in a legal way based on what it is capable of doing?
Well, if you're talking about public investments, then I think then you're talking government in its proprietary capacity, and I think then you do have a focus on maximizing the most appropriate use that will have the greatest impact on the greatest number of people. So if it's a public sector entity that is making a decision on investing, it's a completely different question.
Tim, Gail, any thoughts? If not, go ahead.
I was just going to add something kind of based on the slightly earlier discussion on, sort of this treating everyone the same, or, what's the rent for use of public property. And look in your state at what you do for various similar providers who use the public rights of way. And I'll give you the example of California. In California, there's a law passed like 100 years ago, basically no right-of-way fees if you're a telephone company. You're not paying a right-of-way fee. If you're a cable operator, you pay 5% of gross revenues, but only your cable revenues, not your internet, not your voice over IP phone service, not your security service. If you're an electric or a gas company, you're paying 2% of gross revenues. So when we think about reform of right-of-way charges, I think you have to look beyond even just communications and think, who are the users of your rights-of-way?
I mean, yeah, and I just sum it up by saying one of the premises of your question that you understand that you should treat all services similarly. The problem is, from a local government's point of view, the premise is faulty because often by virtue of federal or state law, you are actually prohibited from treating all of them the same, unless there is one option you have. You could give away your right-of-way free to everyone, and then you'd be treating them all the same. But I mean, in other words, sometimes state or federal law boxes you in. That is the only way you could treat them all the same.
Gabriel Garcia from San Antonio. Wireless providers want access to the right-of-way to install small cells for licensed or unlicensed devices. What do they have to do in order to get access to the right-of-way?
I think that depends on the state.
Second time we've used the word depends. Keep it up.
I'm trying to think of a synonym for depends. But I think oh no, I can't think of one, sorry. Depends on the state what you have to do, because there's an overlay of the federal rules. We talked a little bit about 6409, and that does have rules that apply to wireless facilities in the public rights of way in certain circumstances. And then you have interpretations of state law when you have, for example, in California, very old telephone company law that some courts have interpreted to include wireless. And then you have your local rules. And some jurisdictions deal with wireless siting and have rules that deal with wireless siting in the rights of way. And sometimes their zoning laws or their zoning rules don't include public rights of way, and that's only dealt with more as a kind of utility regulation by their engineering department or public works department.
Yeah, Gabriel, I would add also, I'll just use an example in my state, in Colorado. We have a state law that grants a right to communications companies to use the rights of way without fee, except for the cost of administering a permit process, and subject to local police power. So to the extent that you're in a state where you may have limited rights, but you do have police powers, then you look at the zoning code. Do you have limits on your streetlights and traffic signal lights in a residential neighborhood, or maybe maxed out at 30 feet? Then they want to put something on a pole that makes it 35 feet. It violates the zoning code. So the answer is no. Your standard rules on blocking lanes of traffic during rush hour, all those kinds of things still apply, but it's going to be subject to local and state requirements.
Question from the audience? If not, I have a question here. Are local governments paying enough attention to cyber threats?
No, but you shouldn't feel bad. Lots of sectors of industry in the federal and state government aren't either.
True. Questions, folks? Remember, this is free legal advice. Okay, here's one that we all can relate to. Should passengers be able to use their cell phones on planes? Or let's just go further. Anywhere in public.
Does anyone
I'll
not
get back
do that?
to you on that.
Yeah.
No, except when I use it.
Good answer.
Not in the quiet car.
Drones. I attended a session earlier today about And it was very interesting. All three panelists decided we don't want to call them drones because of the negative concept. So one of them refers to their use of drones as aerial photography platforms, is what they call them. So with that,
Unmanned aerial vehicles, UAVs.
unmanned aerial vehicles, another one. So, speaking of drones, drones are a growing problem. Buzzing airplanes, for example. What are the solutions for this? And as we talked about earlier, technology always is ahead of legislation. We know, I believe, at some point, legislation will happen because of some catastrophe. But in the meantime, thoughts?
Interestingly, we were just talking about this at lunch, and I think when we talk about air traffic and air traffic safety, I don't know the answer to this definitively, but I think federal preemption applies, and I think there are FAA regulations that are going to have primacy in dealing with this.
I know there's a whole panel on it this morning to say that it's sort of typical of where we get sometimes. It does tend to be federal policy, but right now policy is the exact flip of what you would think. That is, if you're a sophisticated user, a commercial user, or governmental user, you are subject to requirements. If you're Joe or Mary Public, you're not subject to any requirements. I mean, yes, you're technically not supposed to do it in the airport area or whatever, but there's no oversight, there's no licensing requirement, there's no nothing. And Ken is absolutely right, but it will stay that way until some big accident happens.
Okay, let's use some of the questions that our panel have put together, and I'm not going to say which questions from which person. Let's see if they can remember it and are willing to answer their own question. The Internet Tax Freedom Act, ITFA, is scheduled to expire in October. The House has passed permanent ITFA legislation, and the industry is pressing the Senate to do the same. Before you answer the questions here, perhaps the person responding to this could explain a little bit more about the ramifications of the Internet Tax Freedom Act, what's at stake for local governments, and why should we care?
Well, I'll answer it since I drafted it. The Internet Tax Freedom Act, which has been around since 1998, does three things, but for what I was referring to is it basically outlaws taxes on Internet access. And then Internet access was defined, actually was expanded to mean, in essence, everything we think of as broadband. So it's not just a prohibition on discriminatory taxes. It is broadband service is, by virtue of federal law, exempt from all state and local taxes, transaction taxes. And what is at stake for local governments, you're seeing it now, is everything is moving to broadband. What you used to think of as telecom is going to broadband. More and more of what you thought of as cable service is going to broadband. From a state and local taxing authority perspective, what you're seeing is the growing part of the economy being tax-free. As a tax policy for state and local governments, where does that leave you? That means, you get to tax the sectors of the economy that aren't growing as fast, the old sectors, you're stuck with them. And if that's your tax base, you're going to be stuck with a shrinking tax base and increasing tax rates, while the fast-growing part of the economy is immune from state and local taxes. And that's the dilemma, the policy dilemma for state and local governments that they face. The political dilemma is once Congress imposes a moratorium, if they ever let it expire, they will be accused of taxing the internet. And God knows you don't want to be accused of that. So that's the raw political problem you face.
Thoughts from Gail or Ken?
We both graciously agreed to give Tim our 1 minute on the tax issue.
You remember, okay. Here's a question, and I think it's an interesting one because I was not even aware of the second part of this question. It has been almost a year since the FCC decision on co-location rules, the Section 6409 rules. If you were at the session yesterday, they talked about that quite extensively. What impacts of these rules have you seen on industry and local government actions? And has the model ordinance, and this was one thing I was not aware of or had forgotten about, has the model ordinance developed by NATOA, NLC, NACO, PCIA, and CTIA had any impact at all?
I think I remember who drafted this question. So in the session yesterday, we asked if anyone was aware, and we had industry folks in that session, for those of you who weren't there, of problems, of challenges, of anyone imposing the shot clock and saying, we are deeming this application granted because the local government has not acted within 60 days, and no one had. So that's a good thing. I do think the model ordinance has been great. It is not the be-all and end-all, but if you've seen it, it's a great place to start. Some communities that I have worked with decided they don't need to amend their ordinance. I actually think it's more important to have a good application than it is to amend your code, because you want to make sure you get every single thing that you need to determine, is this an eligible facilities request subject to mandatory co-location approval, and you've got to make that decision quickly. So you better get all the information that you need to make that initial decision in your application. So my thought was the ordinance is great. The application is more important, and the one problem that I've seen is, while the ordinance itself says this is not mandated, you don't have to adopt this ordinance, this isn't the only way to do it, there have been some occasions I'm aware of where the industry has come into a community that is moving to adopt that ordinance with some modifications and has said to the city council, oh, you can't change that. That's the ordinance that is consistent with the FCC rules. Don't make any deviations or you won't be consistent with the new rules. That is not happening all over the place, but I've seen it and it's not true, so be warned.
The only thing I'd add, I'm sorry.
Go ahead. I was just going to say that I think one impact of 6409 has been that now every application, other than for a brand new tower, the applicant claims that they fall within the parameters of 6409. So it's really important to understand what those parameters are and to vet those applications as soon as possible.
Yeah, I mean, I'd say two things. One, both Gail and Ken's point about the application is important. You need to have an application that's detailed enough that lets you know right off, that basically goes down the definitions and requires the applicant to certify under penalty of perjury when it says it meets this standard, it will be less than this many feet, it will be that, and it will be everything else. You might need to amend your ordinances or your rules, though, because the other problem that a lot of communities have is they have a process for anything that deals with a land use application. It might have to go to the Architectural Review Board, it might have to go through hearing, and the problem is if you have that kind of structure, you're probably going to need an amendment because you need to create a separate shortcut process that will fall within the 60-day deadline. And also, it's a process that, if it is an eligible facilities request, the end result can't be a denial. The end result has to be a grant. Now, it might be a grant with conditions, and that's an educational process to staff, but it also might need some changes in your ordinances, because otherwise, they'll just send it along the usual process through the Architectural Review Board. It'll get there in day 90, long after the 60-day deadline and everything else.
Look, Elrod, Fairfax County. Let's say you have two cable companies coming up for renewal at about the same time. What's the best way to deal with that in terms of simultaneous negotiations or whatever?
Take the weak link, get the best deal, and press it on the other one, ideally. That's easier said than done.
Wait a week and they'll merge.
I'm sorry, Gail, what was that?
I said, wait a week, they'll merge.
Is this a state where marijuana is legal or not? Oh, wait, sorry. I actually like the idea of having two coming up at around the same time because, you know, otherwise, for those of you who have done one and then a year or two later, the next one comes in, you're immediately facing, if you want to make any changes, well, this is what you did there. I'd rather talk about all the issues at the same time.
Next question. I have one for Ken as I walk over here. Knowing that, Ken, you're a big Bruce Springsteen fan, I think you've seen over 50 of his concerts over the years. What's your favorite album by the boss?
Wow, that's a telecom question, huh? It was very cool that Todd put that video together and had 57 channels and nothing on. You remember when that seemed like a lot of channels? I'm kind of old school. I like the first and the second album really well. 40 years old as of last month.
This year, yes.
Wow. Right, and that was the third album. Yeah.
I have heard in a few sessions that local governments should promote broadband deployment, and what they get in return is economic development externalities. Is that a fair a fair argument, a fair way for local governments to view their part in promoting broadband deployment?
I think the second part of your question, Gabriel, the answer is yes. I mean, whether it's economic development, healthcare, educational opportunities, I mean, all of those things flow from better, faster, more affordable, more accessible broadband. My mantra is local control. There are some communities that don't want to get anywhere near doing municipal broadband projects. There are others that only want to create incentives for the private sector. I've got one community right now that is putting in empty conduit all over their city with the intent of saying who wants to use it. We've just made deployment for the private sector much easier. And there are other communities, as we've seen at this conference, like Sandy, who are doing a great job of doing it themselves. So I think the issue for all of us is that the diversity of communities that we have in this nation are incredibly far and wide and deep, and every single one of those communities ought to be left to its own devices to decide what's best for that community.
Steve Trailer from Natoa. As a follow-up to Gabriel's question, actually I'm from Sandy, Oregon, Ryan. As a follow-up, see, oh my gosh. As a follow-up to Gabriel's question, is the concept of universal build-out dead?
In the, probably in the classic old school utility regulation sense, yes. I'm not saying whether that's a good or a bad thing, but it probably is, as far as government compelling it in return, which for the old historical public utility trade-off, you build out every single home, in return I'll give you monopoly protection, yeah. I mean, it is. That doesn't mean that you can't have policies that encourage build-out, that don't transfer funds. USF is a good example, from a pool of all carriers' contributions to carriers that will build out the unbuilt areas. But from a direct sense of, I mean, I think universal service can be a goal, build-out can be a goal, to the extent that it could be, will it be a mandated legal requirement? Probably. I think those days are probably past.
Question? Ken.
No, I agree with Tim. I'd make the comment, though, and as many of us have watched our cable providers basically kick the butts of the incumbent phone company on broadband speeds and availability throughout our communities. Why is that? It's because in the early days of cable, we required build-out to every home, and now the cable companies are reaping those rewards. So I agree with Tim that it probably is over in the regulatory sense of the word, but there are some benefits from it, and we're seeing that today.
State legislation. About 7 years ago, we saw just an incredible increase in states that were, lost local franchising, and really anything's really happened, I believe, on that front for the last 6-7 years, thankfully. Do you see it coming back? And yes or no? And also, for those that are under a state franchising law, what is your advice to, of how to deal with it? And obviously by now they probably learned how to deal with it, but any other advice you may want to give? But first, is it coming back? Do you see any signs of it?
I would say generally not. You have to remember the driving force. There's a few exceptions. Verizon was actively involved in California and Virginia, lesser degree in Texas. But the driving force between most of those state laws was AT&T. And of course, they're done. So I don't think you'll probably see some movement in a few of the CenturyLink states.
Yeah, that's what
But I mean, to the extent you see it, it won't be a wave like it was before, but if you see it, you might see it in the CenturyLink states. But it won't be like it was before. And CenturyLink does not usually carry the state legislative weight that AT&T does. In fairness to CenturyLink, no one does. But as far as living with a world of state franchising laws, well, it changes. It limits your options. To be brass tacks, it probably unemploys some local folks who were in the cable franchising business. So it limits your options quite a bit, and it probably reduces you more to viewing it more as a revenue source, as opposed to, you're no longer in the business of regulatory oversight, so it really becomes a source of maximizing revenue and, to the extent the state law allows it, preserving PEG access. It basically sort of reduces you to those two interests.
Why do you think that CenturyLink may want to try to enact?
Several reasons. One-stop shopping. From their point of view, I don't want to have to deal with, scores of different communities with different requirements. I want one-stop shopping. That's what it's all about.
And what drove it with AT&T and Verizon was they wanted to be able to offer video service over their footprint, not over the footprints that match the local jurisdictions. And so they were going to a state-level franchise where they didn't have that obligation to build out in each community was appealing to them from a network build-out point of view. They wouldn't have to build out. They would just have to upgrade their network where they chose.
And I would say, while I don't think it's coming back in the way we saw it 7 or 8 years ago, I do think it's still there as a threat. And I'll just tell you our experience in Colorado last year. We have an anti-municipal broadband bill, and the Colorado Municipal League and the Colorado Counties organization proposed some modest amendments to that legislation, and it was met with a threat for statewide franchising. And neither one went forward. So we're stuck with our same anti-municipal broadband bill, and we didn't see a state franchise bill last year, but it will be hanging over our heads in response to municipal broadband for a long time, I think.
We talked about Charter-Time Warner merger a little bit ago. Any advice you would give to any of your clients or anybody in here that may be facing that Charter-Time Warner? Is it going to happen? Comcast and Time Warner did not. One of the reasons a lot of people think is because it was just too big. But some people said, well, this is a little smaller. This is not going to have the same impact. I've actually heard a legislator say that. It's really not going to affect that many people, and it's actually good for them. And I'm not going to get into an editorial whether it is or not. I'm just asking you, is there anything that you think you should be advising clients or folks in here that may be impacted by that they should be doing?
One of the differences, I think, in the two is that you didn't mention is the programming issue, the whole, NBC Universal, Comcast NBC Universal, that whole programming issue is not as big here in California, in Los Angeles, the Dodgers channel, that's a big issue. But other than that, they don't have the same kind of programming interest, so I think that helps them. I think they've also, just the way they've been behaving in this merger, they've learned a little bit from what happened with the Comcast merger, and they're trying to anticipate those the kinds of objections that came up in the Comcast merger a little better. Just being a little bit more political, maybe.
Yeah, I think I'd add that, of course, now in fairness, I probably would have said the same thing a year ago about Comcast Time Warner, and it proved to be wrong, so you never know. But particularly for the reason Gail said, because you don't have the vertical programming interest ownership level in Charter Time Warner that you did with the Comcast side of Comcast Time Warner. In size it's smaller, but it's not like it's small. But I think as a practical matter, the odds are that the FCC will approve this merger. The question will become, and what you need to focus on if you do participate at the FCC, is to do what you can to push for conditions on it, because the likely outcome is it will be approved. The question is, what conditions can you persuade the FCC to adopt, which won't be easy, but that's what the issue will be.
And before you answer that, what type of conditions would you suggest?
Well, it will vary. We have one issue that I know was raised in AT&T DirecTV and Comcast Time Warner, and it got some nice language in the Commission's order in AT&T DirecTV, but it didn't get any conditions. Has to do with PEG support. Now, in order to make that argument and propose that condition, you have to put together an argument that there is a risk that this merger will make matters worse. You can't just say, well, I've got problems with them now. Well, yeah, you might have problems with them now. If you have the same problems after the merger, the FCC will say, well, that's not merger related. You have to sort of describe how it would make matters worse. The FCC will be focusing on, as you saw in AT&T DirecTV, far more on the broadband side and the broadband conditions than on the video side. They see broadband as the big issue, not video, not cable.
Ken, you were about ready to say something?
Yeah, so if you have a local franchise that gives you authority to approve a transfer or change of control, you're probably not going to get anywhere close to everything that you want to get, but you ought to look at what kind of benefits you have in your franchise now that you would like to maintain, and at least propose the kind of resolution of approval with conditions that would continue those benefits going forward. If you're near the end of your franchise term, you might want to try to see if you can get a commitment to maintaining those benefits in an upcoming franchise. That'll be hard to do. I don't want to mislead anyone. But the other thing that I've noticed in at least the states where Charter and Time Warner serve rural communities is that because of the way staffing has been done over the years, there's just not enough people to address local needs. Sometimes you have 1 or 2 people covering 3 states. And as these companies get bigger, and some of these communities have gone from Bresnan to Cablevision to Charter, now to Time Warner Charter, it's just the bigger they get, the less availability there is for employees of those companies to serve local communities. And you may want to get those kind of conditions imposed in your local resolution. And if your deadline for intervening at your state public utilities or public service commissions have not expired yet, because their obligation is to determine whether this is in the public interest, and you have those issues about local service and how it goes down the bigger these companies get, you may want to raise that issue on the state level.
Gail, you mentioned the Dodger Time Warner issue a bit ago. Any thoughts on channel blackouts and how you might fix that problem?
I'm not a sports fan. No, I'm a hockey fan, but these issues would never come up about hockey.
It's never been discussed, huh?
No one would, it just doesn't come up.
Does everybody understand the question? If you live in Los Angeles, go ahead, Gail.
Well, what's happening in sports, which I think is the real challenge it used to be that if you had basic cable, you could watch a lot of sports. But all of the there's all these regional sports networks, all these deals, like the Dodger deal it was an exclusive. All the Dodger games are now on the Dodger channel that was kind of related to Time Warner Cable. Time Warner, the Dodger channel only made a deal with a few providers, so there was like a big movement to try and get that channel on other systems. So it's part of this kind of moving, important, must-watch programming off the public airwaves and onto the cable channels where you really have to subscribe for those services, and your cable provider has to have entered into an agreement to actually provide that programming. So I think the blackout issue for the Dodger channel, it's not a blackout issue in the traditional sense. Right. It's is your cable system going to get that programming?
So if you have is it Time Warner?
Yeah.
If you have Time Warner in Los Angeles, you don't get to watch your Dodgers. It's not on the system.
No, you do.
You
if
do.
You have
It's the
Time
reverse?
Warner.
But not if you have AT&T or...
Okay,
Sure.
it's the reverse. That's what I meant. Okay.
Yeah, Verizon and Comcast. They did a deal with Bright House as well, but Bright House is sort of related to Time Warner Cable.
And the short answer is on that issue, that's a little bit different than the blackout retransmission consent issue,
Yeah.
which, by the way, the FCC is issuing a rulemaking. Actually, the text they issued right before they shut their system down for a week to fix it, but it's out now, that they're proposing rules on retransmission consent negotiations that are designed, I won't go into the details, to limit blackouts, the sort of holding customers hostage for the fight between the cable operator and the broadcaster. The issue of sports channels and cable channels that are affiliated with cable operators, which the Dodgers channel is, there is a provision of the Act which was added back in the 90s, a program carriage 629 of the Act, and the FCC has rules about that. You can bring a competing multi-channel provider can bring a complaint to the FCC for instance, to challenge Time Warner's withholding of the Dodgers channels. Now, surprisingly, there hasn't been a lot of FCC-level litigation on those complaints as you would think, but there actually are provisions and rules to address that.
Thank you. Rick?
In the long run, do you think that over-the-top programming is likely to undermine the existing video providers or strengthen them?
I think the existing video providers call themselves broadband providers now.
I'm a little bit more pessimistic than the panel that we had yesterday, and Gigi Sohn's comment about how long cable franchising is going to be here during her talk. I think as things move over to the over-the-top platform, we're going to see, I don't know if it's 3 years or 5 years or 10 years, but eventually a dramatic shift, and I frankly don't see a big future for cable franchising.
Well, and a different question about what it means for the broadband providers themselves. I mean, number one, they'll do just fine. Now, in the cable world, they had the wonderful ability to, in essence, merge the business of transport and content and capture all the revenue, well, not all the revenue, because the programmers got their share of the revenue from it. They're going to be moving into a world where, the Netflixes and other people are going to be able to enter the market and get part of the video content, part of the revenue stream. But as I like to point out to my cable operator friends, you sort of win either way. I mean, even if you if you get cord cutters that go to over the top, in order to get over the top, guess what you need? You need broadband. And in most cases, in most communities, where are they going to get the broadband from? The cable operator. As a practical matter, the cable industry will do just fine. There's an interesting question as to whether, when they move to their only guaranteed revenue stream is the conduit broadband, do they make as much revenue? I don't know. I mean, overall, I think they'll do fine. I think Ken's right. I think longer term, what you're really going to see is the cutting down of cable franchise fees and public interest benefits. In other words, a diminution of cable franchising, as if we haven't already seen a lot of that already.
Oh, and I want to add one other thing, and I think that it's interesting, especially in states where there still is local cable franchising, and that is the only authority that the cable operator has to be in the public rights of way. That cable service will never go away. It might get really skinny, but to stop providing cable service it logically means you're not operating a cable system anymore, so you're not providing the service under your franchise. You've either abandoned your franchise or something unless there's a resolution of that issue, I think there will always be some little anchor of cable service just to keep your authority.
No,
Got a question back there? Yes, we do.
Wendy Karish, South Washington County Telecommunications Commission. What do you think, how would you advise your clients if they came to you and said, we're thinking about putting in some empty conduit around our city. We don't really know what we want to do with it yet, but is it a good idea? And how would we go about that?
Well, I worked with a city here in California that did that. 10 years ago, they started requiring in new housing developments that the developer put in conduit. And it sat there for 10 years, little bits here and there, not always joined up, right? Sometimes it would go to the end of a street, it didn't cross the street, and then another developer put some in another spot. And a company approached them, a smaller internet and fiber company approached them and said, hey, we understand you have this conduit. We would love to use it to build our fiber system. So someone had an idea 10 years ago. Nothing happened for quite a long time, but it ended up turning into a really nice public-private partnership, and they got a competitor in their city. So, yeah. it's a good idea, and, but you have to be patient, and someone has to be an advocate for doing it without knowing what's going to happen in the end.
And you have to monitor, because otherwise you end up with, I mean, it actually is probably a good idea, and the incremental costs are very small.
Yeah.
But what you don't want is happen is the developer just haphazardly, stick it in there and stick it in there, and they don't connect with each other or anything. In other words, you got to monitor it to make sure that it's implemented in the way it was intended to.
But it was easier, in that case, that's what happened. It was sort of hodgy-podgy, but in the end of the day, it was easier to make a few connections than to install a whole conduit system. So even a hodgy-podgy one works all right.
But it doesn't have to be hodgy-podgy if you monitor what they do.
Yeah.
The other thing,
and that's not a technical legal term.
Yeah.
the other thing that I would advise a client to at least think about, if that's the question, is there are plenty of really good NATOA consultants who are not lawyers that do work in this kind of broadband planning, and because if you're putting in empty conduit, there's probably a need to run some fiber for your public safety communications from City Hall to a police substation. And at the time that you're putting in conduit, it may make sense to take a few capital dollars and put it into a city fiber network, which over time, then putting in extra fiber, the incremental cost of that is usually pretty small. It gets back to the question about what's the best thing for cities to do with municipal broadband. Everybody's interests are different, but there's lots of experts out there who can look at what you have and look at what your needs are and help you devise a plan that will give you a better chance that 10 years from now you'll have a really great solution compared to what you're just thinking about, what should we do now?
If you have George Brown, Jackson, Mississippi. If you have a municipality with a new administration who unknowingly executed a terrible franchise agreement and you have renewals pending, what kind of recourse would they have?
So the renewal is pending?
Are you saying that the original franchise from 5, 10, 15 years ago is horrible?
Actually, they executed a brand new franchise agreement, and amongst the new franchise agreement, we have renewals pending that's going to be depending on the language of the terrible agreement that we have.
With another provider. In other words, you just
Correct.
entered into a terrible franchise with one provider, and the renewal is pending for the other provider.
Correct.
You have a problem.
Recall, maybe?
That's not the legal advice you wanted to hear, is it?
No, part of it depends upon, there may be state law implications. There may be Section 253 of the Telecom Act implications about competitive and non-discriminatory treatment of providers, depending upon what kind of franchise we're talking about. And you may have language in your existing franchise that's being renewed, as well as in the terrible franchise that the administration just signed, that limits what the city can do when it is dealing with competitors. And I think you have to evaluate all of that language, and that evaluation will tell you whether you have any flexibility. You may not. You may be stuck.
No, I mean, we're sort of assuming the bad result from the description. I mean, it sort of depends on what that terrible franchise says and other facts. I mean, it also depends on who the bad franchise is with and who the renewal is with. I mean, for instance, if the bad franchise is with a new provider and the negotiations for renewal are with the incumbent provider, provided that the bad franchise isn't so bad that it restricts your other franchise, the FCC has said in the Section 621 proceeding that you can draw distinctions between incumbent cable operators and new entrants. In other words, it is, from the FCC's point of view, and as in other issues, that you can, in essence, potentially, as far as they're concerned, impose more burdensome PEG requirements on the incumbent than you do on a newcomer.
Yeah, that's what I was going to say. If it's a new entrant, then I would rely heavily on that new entrant. It's a new entrant. That, these things happen. We like competition.
It's actually not a new entrant.
Oh, never mind.
You have a problem.
Okay, Alice Lawson, City of Seattle. Given the context that maybe the future of cable franchising is coming to an end, if you're a community that is entering into the next couple of years renewing a franchise, and it might be the last franchise you put into place, what would be suggested elements you would advise that someone would fight for their community?
Before answering that question, I was just going to ask this question. How many here are in the process of doing a franchise renewal or new franchise?
Wow.
About a third of you are. How many are renewals? How many are negotiating just a new franchise? How many both? We know you are. Well, you sort of are back there. So go ahead and answer the question.
How many have a competitor in their service territory?
About two. Okay.
So Alice, the first thing that you want to do is get a provision in your new agreement that doesn't allow Tony Perez to retire until after the franchise expires. If you can get that, and I doubt that you can, the fact that things are changing, I mean, we're up here making predictions, and if we bat 300 on some of the things we're predicting, I think we're doing really well. So cable franchising is still about providing a cable agreement that meets the future cable-related needs of the community. So I go into a franchise now, even if I think this may be the last franchise this community is ever going to negotiate, and you want to get the kinds of things that meet your community needs. So if you have an active PEG channel and you've got 100 channels on your cable system that are in HD right now, but your citizens don't have the opportunity to watch their government access and their educational access and public access programming in HD, if that's important in your community, that's today's issue based upon today's economy. When you look at defining gross revenues, and we're looking at new technologies and being able, interactive cable programming where things pop up on your video screen and every time you click it to get more information, the cable company makes a few cents. You need to make sure that your definition of gross revenues incorporates that kind of activity in determining what you're going to get 5% of, if that's what your franchise fee is. So to me, the fact that cable franchising may be going away at some point doesn't really change the fact of really understanding what is the cable system doing now and what are the needs of the community and getting the best deal you can, just like we always have.
Yeah.
I agree with that. The only thing I would add, I don't think, turn off the light and close the door, the last one out of the room. I don't think, it reminds me, I'm showing my age, almost 30 years ago, in the late 80s when I first started getting into business, people were saying we were involved in litigation, if you all remember the First Amendment litigation of the 80s where competitive franchising was, refusal to grant a second franchise was viewed as a First Amendment violation. And at the time, we would sit around at the firm I was with, Miller and Holbrook, for those of you who are old enough to remember before Miller Van Eaton. We thought, well, cable franchising is going to go away. The states are going to take this over, just like, that's what happened with telephone franchising. The states took it away, and surely it's going to happen sooner or later. Well, that was like, 30 years ago, and here we still are. We're probably closer to the end now, but I agree with Ken. You have to approach the franchise just as you always have. Now, the other thing I'd add, which really isn't anything new now, but it matters, is because of all the other kinds of services an operator provides, number one, and because, two, at least under current law, you might be restricted to 5% of cable franchise fees revenues. One thing you have to be careful in drafting a franchise is to make sure that if you ever get authority later on to impose taxes or fees on non-cable service, you don't want the wording of that franchise to come back and bite you where the operator can say, well, maybe you could, but you've already given me the contractual right to use your right-of-way to provide these services, so I already have it. So you need to structure the agreement so it's limited to cable service. Now, the cable operators argue that as a matter of Federal Cable Act law, if I can provide non-cable services over a cable system anyway, but leave that aside. Federal law is going to be what federal law is. What you do not want to do is create your own contractual problem that you've already given away use of the rights of way for non-cable services in return for just 5% of cable franchise fees.
Yeah.
Alice,
worry
go ahead.
about those two things. Yeah, I was going to say, I agree entirely. Worry about the authority the authority language and the competitive equity language, because those are both ones that are going to bite you.
Alice, just a word of advice from somebody who's just gone through it. Since Tony probably will be gone but before the next franchise, retired.
Right, I should say retired, not gone.
One of the things, you don't look like you may be old enough to deal with this, but was one of the things I made sure was in this franchise is that it was going to last long enough that I was retired before the next franchise came along.
Okay, Dwight Williams, City of Houston. Gail, in follow-up to your statement that cable franchise will never go away, that it will always be there in some minuscule way, how does that affect state franchises? Because you specifically talked about local franchising. What would that look like, and is there even a reason to bring that up?
Well, I said that in the context that as long as that's the only authority for the operator to be in the public right-of-way, then that's an anchor. But if there's reform where they have other authority or they get other licenses or something else, like if you think of the telephone companies like Verizon, have a cable franchise, their cable franchise could come to an end. They're not going to leave the public right of way. They may continue to provide video. It may be over the top video. So but where the traditional cable operators had their only authority that they had to be in the public right of way was their cable franchise, then until they have an alternative authority, they will hang on to that.
Yeah, and I think it's going to be a while anyway. Everyone talks about over the top and the death of what we know as cable service. Definitely that will be the trend line, and you'll see it in reduced cable franchise fees. It will take time, and it will take time for a couple of reasons. One is my generation and the people older than me. They're still out there, and they still like plain old cable service, and they'll still be around for a while. There'll be a market for them. The second problem is an industry problem because the content industries have not figured out a way to monetize the value of their content as effectively as the cable affiliation agreement set up. And until they do, there's not going to be a rush to move everything over the top. I mean, if you're ESPN, until you figure out a way to match the combination of your affiliation fees and your ad revenue from being on a nearly universal tier, until you find a way over the top to match that kind of revenue, you're not going to be in a real huge rush to, abandon the cable model and move everything over the top. And so that's going to take time. I mean, what they don't want to happen to themselves is what happened to the record industry, which never has. I mean, if you look at its revenues today, it never has recovered from the online, and they don't want to see that repeated.
What's a record?
Yeah.
I'm kidding. I know what they are.
Janae Nauman, City of Tempe. So I have two questions, a cable question and then a right-of-way question. So the cable question is, if you're in a renewal, so if you have an incumbent who, anytime there's a new entrant, they're always claiming, competitive equity and equal playing field, kind of disregarding the fact that they have a monopoly. But if you have a license, and what is the effect of just not getting it renewed? If you're arguing about the competitive equity or some provision, and then the license expires. Because I'm looking around at surrounding communities, sometimes their cable license expires and they don't have it renewed. And the question is, what happens?
Well, the funny thing is that situation is more common than you would think.
Yeah.
That communities just don't get the franchise. They're still at loggerheads. They're still negotiating, and the franchise expires. The technical answer is a state law question. In other words, what state law says about, does it become in essence, franchise at will, or month to month, or whatever, as it continues, depends on what state law says. Both parties tend to want to treat it that way, because as a technical matter, under the Federal Cable Act, the cable operator is required to have a franchise, on the one hand. On the other hand, if they timely ask for formal renewal, you can't terminate or end the franchise except through the formal renewal process. So as a practical matter, what usually happens is the parties treat it as just an ongoing month-to-month or whatever franchise. The safer legal thing to do is to actually do an agreed-upon extension for a period of time. sometimes that gets harder to, I mean, that used to be done as a matter of course. Now some cable operators get sort of cantankerous about that, but yeah, that's.
Because what I've seen is, 2 years after it expires, then the government on the agreement says, and then, this is effective as of, 2 years ago, kind of thing. My second question is on right-of-way. So you have jurisdiction over your right-of-way. How much up into the air do you have jurisdiction of your local government?
Until the FAA gets involved.
All right, so let's make an analogy,
This is
right?
a drone question.
We're not, none of us are of this question, but thanks, Janae, you got us thinking. I'm running in my mind the analogy, if not right of way, it's just a parcel of land that the city owns, right? You have authority, as Gail said, somewhat tongue-in-cheek, until the FAA gets involved. Yeah. I think you have significant authority, so if you have height restrictions in your zoning code or public works or public safety related kinds of restrictions that deal with how tall a structure can be, whether it's a pole or whether it's a building, you have that same authority above ground in your rights of way, just as the city would over any other parcel of property that you have.
Yeah. I think that's right. Your encroachment, look at your encroachment permit kind of language. It's, an encroachment of the right-of-way. It's above, underground, on, right? So it's above until someone else takes over jurisdiction, I would say.
That's the right answer. No, that's the answer I wanted to hear. But the reason I asked is it comes up in the context of, we had a situation where we had a company that put things in the, Wi-Fi nodes, for example, in the right-of-way on their existing structure, and we said, right-of-way is right-of-way, and air rights, and you need an encroachment permit. They were not happy, but...
Well, presumably these structures were not suspended and floating in air. Presumably they were attached to something.
They were attached to their own facilities,
yes,
but they were nonetheless in the
overlashed on
right-of-way.
their cable or whatever. But that is,
Right.
yes, that would be in a facility in the right-of-way.
In Seattle, as we prepared for renewal, we engaged in our needs assessment process, and the statute says that we get to address our cable-related needs and interests. And as Alice and I conducted our ascertainment, what we found is that few people cared about cable. People wanted to know about broadband. That's what really mattered to them. So my question is, as more communities begin to, I think, expand the scope of their inquiry during an ascertainment to look at broadband-related benefits, have you seen examples in other communities or maybe franchises you've worked on where communities have been successful in negotiating for broadband benefits such as public Wi-Fi, hotspots, other things like that? And can you name some of those broadband benefits that were successfully negotiated during negotiations?
So this somehow ties back to the first question that Mike asked Gail about, is technology outpacing the statutory framework in which it operates? Because you're right, I mean, we have a Cable Act and it's limited to cable-related needs and interests, and I think all of us would say that any of the needs assessments we've done recently have the same results as yours. We have had some success in Colorado, and I want to give Comcast credit for this. Comcast proposed a creative way to help communities expand their online programming presence. So instead of just having a government access channel that you access through the cable system, most of you have programming online. You've got, you either stream it on your website or you've got YouTube channels. And with a number of Colorado communities, Comcast has been willing, as part of the PEG support negotiations, to provide, a commercial grade broadband connection which the government access organization uses for its upload and download of putting programming in the cloud, and occasionally financial support for some of the equipment necessary to facilitate that. In return for, being thanked appropriately with the Comcast logo on some of the government access online programming to make it clear that this is a new way that we are partnering with the incumbent cable operator to promote that kind of video. So there's one example.
I think it's great we'll end with the president asking the last regular question, but I did ask a question earlier, and I asked all three of you to give it some consideration. I'd like a 30-second answer from each of you, and I'll start with Tim. What is, in your opinion, because you deal with all the broad perspective telecom, broadband, cable issues, what's the next one lurking that may not have risen all the way to the top yet, but you think it's just starting to percolate?
This one, my reaction to it, and some people will say that's because you're a broken record, Tim, and it's already appeared, just it hasn't gotten that much attention, or at least that much devoted effort by states and locals. I think, as we are gradually moving away from the cable franchising world, and there's not going to be a model of, it's not politically feasible to have a local model of local broadband franchising, I don't think. It's going to, the issue that is going to matter, and it's one that sometimes people in this room are less involved than maybe your treasurer or whatever, is it's going to boil down to a revenue issue, to a tax issue, and a right-of-way fee issue. That's what's going to matter. And those aren't issues that have been hidden completely, but I think industry has been several steps ahead of both state and local governments on it, and we've got a lot of hurdles to overcome. But I think going forward, that's going to be what the real big issue is.
Okay. Gail?
I'm going to say, and this one really just popped into my head, I'd like to find a way to say that a wireless video service that relies on a distributed antenna system in the public rights-of-way is a cable system.
Ken?
I was going to say that we had hoped you forgot that question. I said earlier that I didn't have a lot of confidence that Congress was going to get around to doing a comprehensive rewrite of the Communications Act. Here's what I think could happen, and we just have to be diligent in watching for it, that a piece of what would ordinarily be considered in a comprehensive way for a new telecom or new Communications Act is going to get attached to some other bill, just like the 6409 language got attached to the Tax Relief Act. And if we're not on top of it, the issue, whenever they get around to whatever legislation it's going to be called, the issue is there still a need for public interest obligations for communications companies that use public assets, whether they be public airways that are owned by the federal government or local streets that are owned by local governments? And something is going to get attached to some bill without a lot of thought that a few lobbyists are going to write. And if we're not awake and able to motivate quickly, we may get basically sideswiped and lose a big battle before we even know the battle's been fought. So that's what keeps me awake.
Okay, well, thank you for all staying awake, but I don't want to end on that kind of down note.
Right?
Yeah.
So I liked how you responded a bit ago when you said that's the answer you wanted. I heard this many years ago at an ATOA conference from Brian Grogan, another esteemed lawyer friend of ours here. And he was talking about the fact that he had a friend's son who was graduating from college, and it was one question that he had to get right to get out of college. And the question was, and it was a take-home question too, what's 2 + 2 equal? Well, the young man thought, this is too important of a question. I think I know the answer, but I better get an engineer perspective of this. So he went to see an engineer friend. He says, well, that's obvious. 2 + 2, you build it together, it's 4. Thank you. I better get a spiritual perspective on this. So he went to see his clergy. Well, obviously, son, 2 + 2 is the only thing can be is 4. And then he gets an accountant perspective, and obviously the answer was 4. So he figured one final question. Went and saw the family attorney. And he asked the family attorney, what's 2 + 2 equal? And the answer is, what do you want it to equal? And with that, they've answered those questions of how you wanted it to be answered, hopefully today. Thank you very much.